Hi everyone, welcome to the 39A podcast series. I'm Maneka Khanna, and today I will be speaking to Mr. Shri Singh about the recent Supreme Court judgment in Vijay Mandanlal Chaudhary versus Union of India. This judgment upholds the constitutionality of various provisions of the Prevention of Money Laundering Act, commonly known as the PMLA, and it is an incredibly important judgment for reasons that I'm sure we will cover in today's conversation. Mr. Shri Singh is a criminal defense lawyer in New Delhi who specializes in white collar crime cases. He has been and continues to be part of several high profile trials under the PMLA, and therefore I think there are few people better placed than him to discuss this important judgment. Mr. Singh is not only part of these criminal prosecutions, but he regularly appears before the authorities involved in the attachment and confiscations of properties under this law, which is sort of the second aspect um, to this legislation. I personally have had the good fortune of working with and learning under Mr. Singh for over 4 years, so I'm really looking forward to speaking with him today. Before I get started, I just want to sort of set the tone of today's conversation. There has been a lot of discussion on the judgment and the provisions of the PMLA and why the Supreme Court upheld the constitutionality of these specific provisions. In today's podcast, I thought we would instead take more of a bird's eye view of the judgment and the legislation and get Mr. Singh's insights about these broader themes and implications. Sir, I first wanted to ask you, this judgment is monumentous in many ways. It decides more than 20 legal issues related to the PMLA. So, what are your first impressions of it? How have courts and tribunals been responding to it? And what are the implications that you see and anticipate in the future?
Hi, Maneka. Good evening. And thank you for that thoroughly undeserved introduction. I think the first thing that we must mention as we start today's podcast on the 25th of August is that the judgment today stands under a review petition, which was allowed, in which notice was issued by the Supreme Court, and it's been now kept for hearing. The notice was issued a few hours ago, so I'm not sure what the wording of the order is, but from what we could hear, perhaps there may be a limited notice issued by the Supreme Court to review this judgment on two issues. One on the issues of whether the ECIR, that is the First Information Report, insofar as ED is concerned, should be given to an accused or not, something that we'll perhaps discuss. And the second is on the, and more importantly, is on the aspects of doing away with the presumption of innocence with respect to some of the provisions of the PMLA. So the Supreme Court will have a relook on at least some of these provisions. So the finality of this judgment is something that perhaps it isn't as final as it was today morning. From a practitioner's point of view, whatever your views are on the merits of the judgment, it's actually quite a relief that many of these issues have come to some sort of closure. The fact that there were as many as 20, or in fact over 20 issues that were open for discussion in a judgment that was passed by a full bench of the Supreme Court should indicate to you the fluid and uncertain nature of the law as it stood. Whether one says that these issues have been rightly or wrongly decided, depending, irrespective of which side of the line you fall, the fact that some of these issues have been given some shape, some sort of final shape, at least means that for counsel on the defense, you have fixed points through which one can at least begin to navigate. Otherwise, pleadings were becoming very bulky. Stands that had to be taken. Almost every stand had to include a demurrer or a caveat. The views of different high courts were permeating in those pleadings. So again, it depends on which court, which bench, which view was being preferred over the other. And since a large part of the initial interaction that either a defendant in the course of the adjudication or an accused in the course of an investigation, a large part of that interaction with the judicial system is with respect to discretionary remedies. So an uncertain law coupled with an appeal to a discretionary remedy gives rise to terrible uncertainty. So at one level, there is some sense of, there was at least some sense of relief that, all right, this is what we are facing in terms of the law. And then one can go about sort of charting your way through either the investigation or the adjudication. The law is undoubtedly strict. It's a special law. By virtue of being a special law, it is expected to be different both in substance and procedure from the general law. We normally tend to ensure that our special laws are stricter than the general laws. So you already expect a higher burden on the defense from a law like the PMLA. The interpretation that the Supreme Court has given hews very close to what the government would have pitched. It hasn't reached those heights that the government would have liked the interpretation of the PMLA to reach, but it's high enough. It places a very high standard on the accused, but at the same time, I think there is, given the fact that it is a large judgment, I think in the copy that I have, I think it goes over 470 paragraphs, right? The fact that it is such a large judgment covering so many different issues also means that it by itself is going to be subject to a lot of interpretation. So I think that this is not the final word on the matter, but it's a start.
Yeah. I think when the work that I was doing in your office, we were putting, as you said, like 15 grounds for every issue, whether it was the definition of money laundering, is it to be read together? Do you need to project, proceeds of crime as untainted property or mere possession? Things like the reverse onus clause. Does the reverse onus clause apply in the attachment stage of proceedings or only during the trial? As I was reading the judgment, it's exactly what you said. Like, finally, we know that there is an answer. We may not like the answer. We may like the answer, but there is an answer. But so you have that finality. But then, as you said, it's now the review is on, and there will be multiple interpretations of these 470 paragraphs. And so maybe there will be a new kind of uncertainty in the future. But for now, I think what you said is hugely important and an important perspective from a practitioner. So thank you so much for that. And I wanted to touch on something that you mentioned, which is that, the PMLA is a special offense. Money laundering is a special offense. And every time the court was asked to sort of justify why these special procedures were constitutional, it always came back to this justification that it is a self-contained code. It is dealing with this huge offense that threatens the sovereignty of the nation, the economic fabric of society, and therefore regular criminal procedure would not apply. So the PMLA is not the first law to have these special criminal procedures, as you said. So can you tell us a little bit, before we get to the specifics of the judgment, can you tell us a little bit about these special laws and how they interact with the regular criminal procedure in a way? And what are the implications that come from a law that has special courts, special procedures, special investigation agencies?
I have some fairly old-fashioned views on special laws. The need for a special law is a recognition of one of several facts. Either the existing law, either in substantive terms or in procedural terms, is insufficient in some way. or falls short of a required standard that is felt um, uh, by the government or the legislature that would be required, in fact, to deal with an emergent situation. So the familiar suspects that come to mind is terrorism, narcotics, securities law, in India, at least insofar as the penal nature is concerned, that nuclear security, the official secrets act that we have, the sense of the legislature is that given the impact that offences under these heads could have on either national security or the health of the young, or the financial security of the country, there is required from the government to be projected a framework that is swift, strict, and easy to apply, especially in the Indian context. Now, those are all objectives that one really has a difficulty opposing. The nobility, I think, in fact, the word used by the Chief Justice today was that this is a noble law. There's no doubt about it. So that's absolutely right. I don't think you'll ever find a defense counsel saying that we don't need this law. But an academician or a philosopher or a theoretician may put that forward, that do we really need a law like this? But that, I think, is a debate for an entirely different day. The difficulty that we have is, that I have with the current structure of special laws, is that I don't think enough academic rigor has gone into whether or not the procedures and the substantive laws that we've set up as our special laws, whether they have met those objectives. And if a case under a special statute takes as much time to meander through our courts as a general law case, then, on questions of speed, on questions of efficacy, the special law would suffer the same consequences of an inquest that the general law would. In fact, there was an interesting article on The Wire, I think yesterday or today, where I think slightly unfairly, in the context of the age of the Act, Prem Shankar Jha wrote that between 2004 and 2012, according to him, there were only 112 cases that were lodged under the PMLA. And from 2014 onwards, the number of cases that have been lodged are over 5,000. Now, there may be many explanations for that number, and not the least being that the Act itself came into effect in stages over 10 years from when it was first, I think, promulgated in 2002 or 2005, and then moved on to then. But the number that is disconcerting, if his numbers are correct, are that they have yielded only 23 convictions. Now, that is an abysmal number. If it's correct, I mean, even if I multiply that figure by a factor of 10, that's still an abysmal number. The purpose of the Money Laundering Act is not, to my mind, is not to make attachments, provisional attachments of assets. It is to punish, ultimately, persons who are involved in money laundering and take down those networks. It has an additional service that it provides, which is it provides adapters all around our system that enables our system, our domestic legal system, to plug into an international system. So those adapters have to be functional adapters and not just there for the sake of being there. And that is something that we have seen in our statute book in special acts from the NDPS onwards. The NDPS, the Narcotics Act that we have currently, is an act that coincides with the US war on terror, war on drugs in the 80s, when the Reagan administration was going against assembly, meetings, resolutions, and general sense that domestic narcotic legislation for everyone needs to be at a certain level so that we are punishing the same things, we are doing it the same way. And that also included money laundering aspect, penalizing money laundering networks within that. So there is a larger purpose for the Money Laundering Act. And that's something that, in fact, the Solicitor General raises in his submissions in Vijay Mandanlal Chaudhary. But I think that aspect of that's an objective. But we need to assess as theoreticians, as academicians, as persons who are interested in the legal system, whether the system is actually meeting those objectives. Because if it is not meeting those objectives, merely having these provisions on our statute book are less than helpful, because it gives us a false sense of security that we have armed ourselves with a statute that protects us from some admittedly heinous ways in which bad money can inveigle itself into your financial system, corrupt your system, and create havoc within financial structures. But that is a false sense of security if those provisions aren't functional. So our system of special laws is robust in terms of the number of statutes we have, the number of the provisions, our understanding of those provisions. But whether they are effective or not is something that perhaps we haven't paid enough attention to. And the PMLA is one such. There is a lot of attention going into the PMLA now. So hopefully that should yield some results.
Oh, thank you so much for that, sir. And that's why it's always a pleasure to speak with you, because I think there has been just so much attention on the constitutional and rights-based implications of these special legislations. And while those are incredibly important, the follow-up question to ask, which is the one that you have raised, is even if we accept that these special provisions or these strict procedures are good or bad, the second question is, do they work and are they serving the purpose? And it seems that the PMLA, with the numbers that you mentioned, it seems like it is perhaps not doing the job of, breaking down these international financial networks. And in that case, we have these sort of strong laws, which definitely do have these rights-based implications. And still we don't have the results that these laws are supposed to yield. And so it's a double whammy in that sense. And I'm really grateful that you mentioned the NDPS Act, because that is, something like the PMLA, as you mentioned, comes with a lot of international pressure. It again has these special provisions. And recently, the Supreme Court, in the Tufan Singh judgment, did sort of say that although the Narcotics Act is a special act, the police officers in that or anyone enforcing that law, they will be regarded to be police officers, and therefore some constitutional protections or some criminal procedure rules that apply to police officers will apply. And but when it comes to the PMLA and Vijay Mandanlal Chaudhary, the Supreme Court said, yes, special statutes, the PMLA is a special statute, but it seems to be that it's different from the NDPS to the extent that this police officer rule does not apply to the PMLA. So now we have many special statutes, and in some cases, they're seen as analogous and similar to each other, but in some cases, they're not. So even within the special statute world, we have these sort of dissimilarities and similarities, which can be quite confusing. So it would be very helpful for us to have your thoughts on it, and how do you see these things play out?
No, you're absolutely right. There are, say, for example, if you take the question of bail, that the twin test in terms of Section 45, the Section 45 of the PMLA, which introduces the twin test for the grant of bail over and above the normal considerations, one of which is that you must demonstrate to the court as an accused that you yourself have not committed this offense. This formulation that I as the accused have not committed the offense, there is a prima facie case that I'm innocent, there is a prima facie case that I am guilty. These various this particular clause in different formulations occurs across the UAPA, which is the Unlawful Activities Act, which also has a twin test, I think 43D5. It also exists in the NDPS. It exists in the PMLA. It also, I think, exists in the Companies Act in the context of the SFIO, the Serious Fraud Investigating Office. So, but the fact that the twin test is worded differently in each of them has not given rise to a Supreme Court finding that, look, it's just a draftsperson's view on how it should be there. The twin test is the same for everyone. It's the twin test is that you should be able to demonstrate at a prima facie level to a court that you have not committed the offense. That would have been a logical approach to deal with the dissimilarities of the language of a special test that exists in several special statutes. That's what someone would have probably thought is logical. But the Supreme Court in K. Najib and in other judgments has taken a different view, also logical, but not apparent at first glance. They have interpreted those various differences and nuances and picked up on those words and have graded, for the purposes of the twin test, have graded the various special statutes to say that special statute A actually provides a standard that is less strict or more lenient when compared to special statute B, when compared to special statute C. Now, that's not the Supreme Court's fault, because the Supreme Court will rely on purposive interpretation or on strict interpretation and say that this is what the legislature has given us, and we have to find meaning in those words. So we can't, with a broad brush, wish away those distinctions, which at one level is very reassuring that the Supreme Court would, in given cases, go into that. These are cases under where the NIA was investigating, I think, UAPA provisions, and they were trying to find whether the UAPA provisions of bail under 43D5 are less stringent or more stringent than equivalent provisions under the NDPS. And they came up with an answer for that. But what's disconcerting is that the legislature has not been able to keep a single test going in what is effectively a handful of statutes. And there is no guidance from the legislature or the executive of the time as to why the second statute is not borrowing the same language from the first statute. So is it really just a draftsman's error, or is it a deliberate attempt to do something slightly differently? And if so, it should have found its way in some note or the other, so that is explained. The issue, therefore, today is open as to whether the officers in charge of conducting PMLA investigations are police officers or not. Open in the sense it was an open issue. Vijay Mandanlal Chaudhary says they aren't officers. There are consequences to that provisions that would ordinarily protect an accused from a well understood statutory bias against the police that exists in the 1872 Evidence Act says that if you make a statement before a police officer as an accused, that statement will not be used against you. It has absolutely no evidentiary value. That is vacated merely because of the nature of service that the officer who is conducting the interrogation under the PMLA is different from that of a police officer. And there are the statute makes an attempt to try and give certain ancillary powers to those officers. But those powers come with greater sense of responsibility for those officers. Those powers, the statute doesn't give it willy-nilly to every officer. The statute will prescribe that these particular powers, which are far beyond that of a normal police officer, are being given to an officer of a certain rank and above. Therefore, implicit in that is that those powers are to be used sparingly Those powers are to be used with responsibility. And those powers are to be used in a manner that, if judicially reviewed, are judicially reviewable. That means they must leave a record. If you can't really have cavil, any cavil in fact, with what the statute is suggesting, that these are sophisticated offences. They require a police officer perhaps does not have every police officer perhaps does not have the expertise to deal with this. They require a special class of investigators. They'll have better training. And implicit in it is that they will have fewer cases to focus their expertise on. In that case, one of two things needed to happen. Either we need to expand the ED in terms of the number of officers. We need to expand the adjudicating authority in terms of the number of adjudicating authorities that exist, the number of officers who are capable of doing that. We needed to have a functioning appellate tribunal under the PMLA, which for effectively about 2.5 years has been defunct. It started, I think, thankfully, a few days ago. It's restarted. And all this lack of infrastructure, which is again all at the hands of the government, is compounded by whatever else the general law and the general lack of infrastructure in terms of delays, etc. So this will only compound that. Eventually, everything boils down to going before the High Court and the Supreme Court, who have several other jurisdictions to take care of, apart from simply, this kind of these elevated special statute provisions. I go back to a very simple principle. When the OECD was trying to come up with an anti-bribery, anti-corruption statute, one of the issues that they had, or so we are told, is how do you compare different legal systems, common law systems, the so-called continental civil law systems, and how do we bring some kind of equivalence between their provisions? If, say, the UK has a particular statute, France has a particular statute, they have different understanding of those statutes. How do we know as experts whether France has met the criteria that the OECD has set up, or for that matter, whether the UK or the US have met the criteria? So they came up with the principle of functional equivalence, that we will not only look at the letter of the law, we will look at the informal rules and practices, and we will look at the overall legal effects, and we will assess the overall legal effects that have been produced by a particular legal system. And it is those effects, those echoes in their legal system, that we will assess and determine whether or not functional equivalence has been reached. And that functional equivalence is then measured up against their convention, that this was the standard of the convention. Have you met that or not? I think we need to do something similar with respect to these laws. There needs to be some kind of an academic audit, not done by practicing lawyers or judges. It has to be done academically by persons like you, where an analysis is done as to whether or not these provisions, coupled with the manner in which these provisions are put into force, how these provisions are interpreted, how persons who go through the system are treated by the system, are dealt with by the system, and whether or not all that ties up with what are the objective goals that this particular statute had. And those goals ought not to keep on shifting. There will be shifting of goalposts, as we are seeing in narcotics law, where there is now decriminalization of certain laws. So there will be some shifting of goalposts, there's no doubt about that. But we need to be very clear on whether the statute, as it is interpreted by this judgment, whether the statute itself is doing justice to its objectives. An additional issue there is, if this is a statute that requires to cover very serious and heinous offences, it requires to allow India to be plugged into a regional or a global system to contain money laundering. If these offences are of a nature that affect our financial structure, then both in terms of the staffing and the structuring of the tribunals and the authorities, there is one adjudicating authority right now for the entire country. And if these numbers are correct, and if, let's assume, he's been there from about 2000 and at least 16 or 17 onwards, And if it's not 5,300 cases, it's 2,500 cases. Like, let's take half of that number. You can't expect an individual to deal with 2,500 cases in a time-bound manner, 6 months to deal with each one at the adjudication stage, and to come up with an answer as to whether I have confirmed it or whether I have not confirmed the provisional attachment orders that are being passed by DT. It is inhuman for us to expect him to be judicious. So we aren't giving ourselves the tools to allow for these provisions, wonderful as they may be, to do what it is that they're meant to do. So that's on the aspect of staffing. But on the aspect of how many offences are we shoehorning into the PMLA, into its schedule, for the PMLA to work its magic in terms of determining whether proceeds of crime have taken place or not. The Court of Appeals, in fact, the Delhi High Court recently, Justice Yashwant Verma, passed an order in the Prakash Industries case where he quoted a Court of Appeals decision from 2010, which described money laundering as a parasitic legislation. Till now, I used to describe it as a second degree legislation. Parasitic is a little is strong, but shorn of its negative connotations, it is parasitic because it feeds off the schedule offense. But if your schedule offenses or your list of schedule offenses keeps on increasing, includes offenses like copyright violations, then you yourself are trivializing the use of this statute, and it is incapable now of only meeting its objectives, which are its noble objectives.
I think that's really important because I think we sort of as lawyers tend to fixate on courts and interpretations given by courts, and courts do often have sort of conflicting standards of, for example, what I started the question with, who are police officers and not. But I think the perspective that you've offered is so much more important, of sort of zooming out and being like, first let's start with the legislature. How are you wording all of these special laws? Why are you making them slightly different but mostly similar? And then moving on to larger questions of infrastructure. How are these institutions that are supposed to be running this special self-contained code being staffed? How many people are there? Do they have the institutional capacity to carry out this noble objective, as the Chief Justice said? And then I think the point you raised on functional equivalence, I mean, that is just so important, to really look at these laws holistically and see what actually is coming out of these laws. And I don't know when this exercise will be done, and I don't know by who, but it definitely must be. I won't take more of your time, but I think I just wanted to end our conversation with sort of a really broad picture sort of view, which is that, the PMLA, as we've spoken a little bit, and other people have called it sort of a Kafka-esque law, right? The ED can come in, attach your properties, you can get arrested by the ED, you can be subject to a multitude of proceedings, whether it is the attachment of your properties or your relatives' properties, as well as criminal prosecutions under the law. And now with the Supreme Court judgment, the ED can do this with few checks and balances, in terms of they have a lot of power to sort of undertake all of these actions. So I wanted to get a sense of what you think of this law and what it means for the rule of law in general, to have such a law on the statute books, which proceeds in the way that you said it does, with one officer sitting over 2,500 cases. And where do you see this going, and how do you see this judgment playing into how this law is operating on the ground?
See, I think there are a couple of trends that are coinciding. We have there have been a series of judgments in the last 18 months or so, 2 years or 18 months, on bail jurisprudence. In fact, ending with the Until's case, where the Supreme Court has suggested that we in fact now need a separate bail statute because just trying to figure out what is the mechanism for grant of bail in each individual statute has now become overtly tedious. Because each statute or the makers of each individual special statute are finding newer and newer ways in which they avoid going back to the general law. And I think from a draft person's point of view, that is a serious error, because the existing general law is actually flexible enough to cover a number of situations for which the special laws have tied themselves up in knots trying to get out of the ambit of the general law. They would be far better served by just sticking to the general law in a variety of different provisions, right? So, for example, there aren't separate provisions for the medical examination of the accused because they think that the general law is good enough. But that's also true for the general law on searches. It should be true for the general law on making statements before a magistrate. The existing procedures, the existing special procedure in the Prevention of Corruption Act, or the 88 Act as amended, has also been changed by the PMLA to change the nature of a trial, which is also a special trial. Now, there may be very good reasons for that. But those reasons, as students of the law, we have been left to our own devices to divine those reasons. We are not given at least the thinking of the government as to why is a special trial under the PMLA a sessions triable case, whereas a special trial, the trial under the PC Act or the Prevention of Corruption Act, was a warrant triable case. Why did you feel the need for that? And the fact that these trials and these provisions and these various interpretations are also subject to a statute that is being amended quite frequently, and frequently enough to give pause for us when we are practitioners to actually come up with tables as to how that particular provision has evolved over the last 10 years. And then there are arguments on, which, at what point of time will which definition be used, right? So suppose the FIR is being, the ECIR is being lodged on so-and-so date, well, the definition was this, could I have, in the last 10 years, would you take it at the stage of summoning? Will you take it at the stage of charge? At what time of day I'm seeking bail? So in that context, if you're looking at if you zoom in really closely, it is Kafkaesque. It is a little strange. Yeah. But again, it's not Kafkaesque in the sense that it is unknowable. If you zoom out, if this is not a case of defense good and government bad. Right? There is an ostensible and a good reason, a logical reason for these statutes to be present on your book. But if these special laws, these individuals who are tasked with enforcing the special laws or reviewing the special laws, don't always perform their tasks with intellectual integrity, right? Quite apart from whether they are otherwise integral. That's an entirely different debate altogether, right? And that is not limited only to special statutes in terms of whether there is political pressure or there's corruption. That's there, unfortunately, across the board. Those allegations are there. That's something we can do without in terms of just trying to analyze this in particular. There is an intellectual integrity that is required to put these provisions into action, because if they are used on an everyday basis against everyone for every trial, against a journalist, against a businessman, against a small trader, against a big politician, against a small politician, against an opposition politician, against politicians who've fallen out of favor, against police officers, against everybody, it's no longer very special then. It's not a very special law. It's not a special law. It's something that comes in some perception. It comes with the territory. So then that's really where the law opens itself up then to criticism, and we tend to want to throw the baby out with the bathwater, that this entire law is bad. That's not true. There's law in some form or the other. You've done matters where we've examined that some form of this law was introduced by the British during World War II in the 1944 Ordinance, which is one of those unfortunate zombie ordinances that still survive till today. So this is not a new law. These provisions aren't new, but there is greater scrutiny that is coming on the law, which is perhaps welcome. So the implication on the rule of law is that if a perception starts going out that this is a law that is subject not only to, that is unknowable, that even the superior courts, constitutional courts are grappling with, are not able to come up with clear formulations of what it is, then from within the country, perhaps there would be less of an issue of perception. But from outside the country, from persons who are, or institutions that are interested in working with India, if they start getting a sense that merely because they have these statutes on their books does not mean that they're actually doing the job that they say they're doing, the level of cooperation, which should be increasing over time, will start suffering. And we, in fact, are in an era where there is an increase in cooperation. There are, we are seeing on the ground that the government is asking for cooperation from foreign governments and is receiving them. So presumably, we are also being asked and we are giving the same amount of cooperation. So all the more reason for these institutions and these officers and these statutes, etc., to be even more robust. Because with greater international interaction, these laws are going to be called into question in more and more jurisdictions, and we're going to have to answer that. So in that context, this judgment is helpful because it gives certain reasons, right? I'm sure there are many views on whether those reasons are good or bad, but it provides a baseline for that discussion to move forward.
Yeah, thank you so much for that, sir. And I think in today's review proceedings, the Solicitor General referred to sort of this is part of a global effort. And what you said is so important in terms of we need this law to have sort of sense of clarity, a sense of certainty, a sense of workability, not just for ourselves, but for us to fulfill these international obligations that this law has set out to fulfill. And for all of these reasons, I hope that there is some sense of clarity and the law, as you said, doesn't keep spiraling and growing bigger and bigger in terms of its scope without having the kind of clarity and institutional capacity that it needs to become workable. And I think these insights are incredibly important for anyone interested in this law and the implications of the Supreme Court judgment. So thank you very much for that, sir. And with that, we'll wrap our conversation up.
Yeah. Thank you, Maneka. Pleasure speaking to you.
Yes, sir. Thank you.